Well, good morning, everyone. My name is Jeffrey Salant. I am the HOA Information Officer for the Division of Real Estate, which is a division of the Colorado Department of Regulatory Agencies, also known as DORA. This morning, we are going to talk about the Colorado Common Interest Ownership Act, also known by its initials, CCIOA or Kiowa. We'll discuss some basic information about living in and governing an HOA. Specifically, we'll discuss Kiowa and its purpose, what it means to be a member of a homeowners association, what community association management is, and the difference between self-managed and professionally managed associations, the lack of regulatory oversight of HOAs and community association managers, and what that means for association members, preparation as a potential purchaser in an HOA, the financial responsibilities of living in an HOA, and finally, we'll wrap up today's presentation with a discussion of Section 38-33.3-316 of Kiowa, which is regarding the HOA's statutory right to impose a lien for assessments. Keep in mind that this presentation is intended for potential purchasers of property within an HOA, but will also have helpful information for those who are already living in an HOA. There are two handouts attached to this webinar, a PDF copy of this presentation and a copy of the Colorado Common Interest Ownership Act. You may download these handouts at any time by clicking on the blue links located under the Handouts tab on the GoToWebinar control panel. In case you are unfamiliar, this is what the GoToWebinar control panel looks like. The highlighted section shows you where you may access the links to today's handouts. If you're having any trouble accessing the handouts, please contact me after the webinar for copies. Please note that the information provided during this presentation is for educational purposes only and is not meant to provide or to be construed as legal advice. Any legal questions you have should be directed to your attorney. I'd like to take a moment to talk to you about my office, the HOA Information and Resource Center. The HOA Center is a statutorily created office, and my position, the HOA Information Officer, is appointed by the Director of the Division of Real Estate. Per statute, the HOA Center provides information to homeowners regarding their basic rights and responsibilities under the Colorado Common Interest Ownership Act. It gathers, analyzes, and reports information through complaints and HOA registrations, and writes an annual report, which is made publicly available. It creates resource materials, provides education, and presents HOA forums such as this one. And we also maintain a website with information for the public, and we also register HOAs. As for what my office does not do, my office is not a regulatory program. We do not mediate or arbitrate. We cannot provide legal advice. We do not act as an advocate. We cannot assess fines or penalties, and we do not enforce an HOA's failure to register. So here in Colorado, HOAs, or as they're formally called, common interest communities, are governed by the Colorado Common Interest Ownership Act, colloquially referred to by its initials CCIOA or Kiowa. This statute defines the rights of the unit owners as well as those bestowed upon the association. It also defines the responsibility of an association as directed by its executive board. Kiowa provides for the enforcement of those rights and responsibilities through civil litigation. Unfortunately, the state has no authority to intervene in any association member's conflict with their association, nor does it have any jurisdiction to enforce the rights and responsibilities defined in Kiowa. Succinctly speaking, there is no regulatory oversight of HOAs in the state of Colorado. Any dispute between homeowners or a homeowner and an HOA is considered a civil matter. While membership in a very few number of HOAs is voluntary, the vast majority of HOAs in Colorado are mandatory. This means that membership is automatic upon purchasing your home, townhouse, or condominium when it is located in an HOA. The relationship between an association and its members is contractual in nature. The terms of that contract are the governing documents collectively as supplemented by Kiowa. When you purchase a property located in an HOA, the recording of your deed is similar to your signature on a contract. When you purchase a home in an HOA, you agree to restrictions on the use of your property through covenants and rules. Decisions made by persons who you may not know can affect the use and enjoyment of your property, your lifestyle, your freedom, and your finances. There may be decisions made by a few persons on the executive board or committee that do not reflect the view of the majority of the homeowners in your community. If you do not agree with decisions made by the board, your first remedy is to use the democratic process. Seek election of other members of the HOA that are more sympathetic to your concerns, which may be a difficult process in an HOA where members are not active. Seeking election yourself is also a great way to try and obtain some oversight of your community. You may also wish to attend board meetings and appropriately voice your concerns on any given issue at the appropriate time. However, with respect to items that the board has complete authority over, such as the hiring of a community association manager or the manner in which maintenance is performed, attending board meetings and voicing your concerns on any given issue may be the extent to which you are able to influence the outcome. However, in circumstances such as covenant violations or architectural review committee findings, you may try to engage your board in alternative dispute resolution, such as mediation or arbitration. However, this is a voluntary process, and if your board refuses to participate or the process is unsuccessful, your last resort will be to contact an attorney and file suit in court. Community association management involves all aspects of operating a common interest community. In a self-managed community, the association will utilize volunteers, specifically the board of directors, to do all of the work. Everything from the management of the association's daily routine tasks to the enforcement of rules is done by volunteers from within the association. The roles and responsibilities of boards can generally be divided into delegable duties and non-delegable duties. Delegable duties may be delegated to volunteers, while the board must execute their non-delegable duties. So what is professional community association management? Well, generally speaking, it involves performing services as the agent of the board of an association. As agent, the community association manager performs services in connection with some or all of the delegable duties of the board. These duties might include the collection of dues, enforcement of covenants, rules and regulations, the sending of notices, record retention and production, bookkeeping, drafting a proposed budget, filing insurance claims, and assisting the board in coordinating meetings. Now, these are just a few of some of the board's delegable duties. Some examples of non-delegable duties might include voting on community issues, voting on appeals of community violations, adopting a proposed budget, and waiving dues, fees, or fines levied by the association. Community association or CAM licensing and regulation previously existed in the form of the CAM program housed at the Division of Real Estate from January 1st, 2015 to July 1st of 2019. In May of 2019, the Colorado General Assembly passed House Bill 19-1212, which concerned the recreation of the CAM licensing program. The bill would have continued the CAM licensing program administered by the division for 1 year. However, on May 31st, 2019, Governor Polis vetoed HB 19-1212, and the CAM program expired on June 30th, 2019. In addition to his veto, the governor also issued Executive Order D-19-006, directing a stakeholder process to examine community and homeowner associations. Currently, there is no regulatory oversight of HOAs or community association managers. Although neither the HOA Information and Resource Center nor the Division of Real Estate have any investigative or enforcement capabilities to address HOA complaints, we do accept complaints and record the issues and matters of concern into a statistical database, which is later compiled into an annual report. In 2020, 21% of all complaints received by the HOA Center were filed against a community association manager, and an additional 16% were filed against both the manager and the board. It is important as a homeowner to understand the distinction between the board for your HOA and the management company. Whereas the management company is responsible for the day-to-day maintenance and upkeep of the HOA, the board is ultimately responsible for all decisions of the HOA. Before purchasing in an HOA, you may want to learn the name of the management company, if there is one, and research its reputation, since they will also become part of your life in an HOA. When budgeting for a home purchase as a potential buyer in an HOA, it is essential to know what the dues are and to understand whether additional special assessments are projected. According to Colorado law, during the negotiation process of the purchase of a home of real estate, the seller is required to disclose whether the property is located in an HOA. Prior to making a decision, new home buyers should obtain and review all of the documents required to be provided to the buyer by Section 7 of the Contract to Buy and Sell in order to determine the financial health of the HOA. The seller should provide you with the HOA documents, including a copy of the covenants, bylaws, minutes of the most recent annual owners meeting, minutes of any board meetings, and the most recent financial statements, if available, during the 6-month period immediately preceding the date of the contract. While brokers should assist in facilitating the provision of these documents for their clients, they should not try to explain them. Any questions about governing documents or financial records should be addressed with a qualified community association attorney or CPA. Generally, there are 2 types of assessments: regular, also known as dues, and special. Regular assessments are typically paid on a monthly, quarterly, or annual basis, while special assessments are usually less frequent and made on an as-needed basis. Regular assessments go towards overall operational maintenance costs, while special assessments are made for a specific purpose, such as a repair, replacement, or new construction. Potential purchasers of property in an HOA should work with their broker to ensure they are informed of any upcoming special assessments. The title company may have this information available, and buyers should also review previous meeting minutes for any indication of an upcoming special assessment. Each unit owner is liable for the payment of the assessments levied against their unit during the period of ownership. While associations may allocate assessments using different formulas, no unit owner is exempt from the payment of assessments because they haven't used any of the common areas or if they've abandoned their unit. It is absolutely essential that each unit owner determine what their financial obligations will be as an owner prior to closing on that property. One of the several responsible governance policies that HOAs are required to have is a policy on the collection of unpaid assessments. This policy should include items such as the due date of the assessment, as well as the date it is considered past due, late fees and interest that may be charged, and any payment plan options, keeping in mind that Kiowa requires that an association, upon request, make good faith efforts to coordinate a payment plan with a delinquent unit owner who has not already entered into a payment plan with the association. A collection of unpaid assessments policy should also include notice requirements and a description of the action required to cure a delinquency, keeping in mind that Kiowa requires an association provide at least 30 days to cure a delinquency. One of the most powerful tools available to HOAs in Colorado is the statutory lien. A statutory lien exists on any unit for any assessment levied against that unit or fines imposed against the unit owner. Interestingly, unless an association's declaration provides otherwise, Kiowa describes the term fines imposed to include fees, charges, late charges, attorney's fees, fines, and interest charged against the unit. The association has a super lien, meaning it has priority over all other liens except those recorded before the declaration, mechanics or material man's liens, and real estate liens and other government assessments or charges. Generally, liens have to be recorded to be perfected. However, in Colorado, the recording of an association's declaration constitutes record notice and perfection of the lien. The association need not take any further recordation of any claim of lien for assessments for the lien to be valid. Interestingly, an association has 6 years from the time the full amount of assessments becomes due to institute enforcement actions. A lien for unpaid assessments is extinguished unless proceedings to enforce the lien are instituted within such a frame. Upon request, an association is required to provide a written statement of the amount of the assessment owed by and currently levied against a unit. This statement must be provided within 14 days. If the association fails to provide the statement, the association may not assert a lien for the unpaid assessments due as of the date of the statement. The statement is binding on the association, the executive board, and every unit owner. An association's lien may be foreclosed upon in a similar manner as a mortgage on real estate, but only if a unit owner's delinquency exceeds 6 months and the board has formally voted to authorize the filing of a legal action. The board may not delegate this duty to anyone else. Importantly, any legal action filed without evidence of the recorded vote authorizing the enforcement action must be dismissed. No attorney's fees, court costs, or other charges incurred by the association in connection with an action that is dismissed for this reason may be assessed against the unit owner. If an association obtains a judgment in their favor under Section 316 of Kiowa, they are entitled to recover their costs and reasonable attorney's fees. Attorney's fees for judicial foreclosures are typically billed on an hourly basis and typically average $3,000 to $4,000, with costs averaging $600 to $800 for filing costs, serving the defendants, title work, and any applicable sheriff's charges. Whereas the attorney's fees for a contested foreclosure may run in excess of $7,000, depending on how vigorously the defendant defends the case. When enforcing any association policy, including the collection policy, it's important for the board to maintain consistency in their application. At the same time, it is also important to recognize special circumstances. Balancing the needs of the association with reasonable compassion for your neighbors is a significant challenge for boards. Be sure to communicate as effectively as possible. Although it may be necessary at times, using the association's legal counsel to communicate with delinquent members, it can be costly and should only be used when absolutely necessary. Remember that effectively communicating includes effectively listening. Invite your members to provide feedback on association processes. While the board of directors gets the final say in most circumstances, understanding how your membership feels about the association's processes and procedures may help to make them more effective. People are always more likely to follow rules that they agree with. As a homeowner in an HOA, quite obviously, keeping current on your HOA assessments is the best way to prevent an association from foreclosing on your home. Many times homeowners will reach out to me and tell me that since their HOA isn't doing maintenance or is doing a poor job overall, they're not going to pay their dues. I cannot say this loud enough. This only hurts the homeowner. The association can and will go after delinquent homeowners, and they can and will charge them legal fees for doing so. As with most circumstances in an association, communication is paramount. Ensure that the management company or board has your accurate contact information on file. You should also consider communicating with your board in writing once a dispute arises. This may help to preserve evidence of certain correspondence if litigation later does become necessary. Finally, strongly consider participating more in the governance of your association. Attend every board meeting and every membership meeting. Talk to your neighbors and your board members. And lastly, strongly consider running for the board yourself.